Welcome to the Veterans Legal Lowdown, where CCK Law attorneys and advocates break down the latest developments in VA disability law. In today's episode, we're going to talk about a piece of legislation that might change the VA appeals process in some good ways and not so good ways. We're also going to talk about what a VA-accredited attorney and advocate can do for you. And finally, we'll talk about some ways you can increase your combined rating by filing for secondary service connection due to a service-connected mental health disability. Before we get started, a quick intro. CCK Law is the nation's largest veterans disability law firm, and one of the ways we like to give back is with free legal information and content. Our firm has over 2,500 published blog posts and 900 videos, and just recently we hit 100,000 subscribers on YouTube. We now have this podcast too, and you can get us on Spotify, Apple Podcasts, or wherever you get your podcast fix. So make sure to like, share, and subscribe, and leave questions and comments for us so we know what to provide for you in our next set of videos. For this episode, I'm joined by my colleague, Mike Lestrito. Mike, tell us about yourself.
Thanks, Emma. So I'm Michael Lestrito. I'm an attorney here at CCK. I've been at the firm since 2016, believe it or not, so almost a decade now. I started when I came to the firm working cases before the Court of Appeals for Veterans Claims. And so appealing board decisions on behalf of disabled veterans and their family members to the court. Then during my time here, I transitioned to working cases at what we call the agency level, right? So cases that we're prosecuting at the various regional offices all the way up to the board. And so in my role now here at CCK, I am a managing attorney, and I oversee a team of paralegals and other attorneys as we develop the evidentiary record for veterans, appeal their case, file claims, but all at the agency level, right? So at the regional offices and before the board.
Great. And so we'll have a good discussion today because Mike has perspective on both what it's like at the CAVC, the Court of Appeals for Veterans Claims, and working before VA. All right, Mike, so in our first segment, we're going to talk about secondary claims to mental health service-connected disabilities. Before we dive into, kind of the ultimate goal is how can veterans increase their combined rating by filing for these? Go ahead and remind us, what is secondary service connection?
So secondary service connection involves a secondary condition or a condition that is caused or worsened by an already service-connected disability. So in the context that we're speaking here today, mental health disabilities, oftentimes a veteran will have a mental health disability, whether it's PTSD or depression, anxiety, and that service-connected disability will be the cause of or worsen another, what we call secondary condition. And so by virtue of the fact that the service-connected mental health condition caused or worsened this other condition, this secondary condition can also be service-connected. And that's really critical for a number of different ways. But I think importantly, one thing to remember is that if a veteran is able to obtain service connection for this secondary condition, that is rated on its own and separate from the prior service-connected condition that led to that condition being service-connected. And that's a great way to increase, a veteran's overall disability compensation. You still need a diagnosis for that secondary condition, and you still need what we call a nexus or a link that links, the secondary condition to the primary condition. In this case, the mental health disability.
Right.
So that doesn't change. That the basic rules of service connection, they absolutely still apply. But it's a great way to pursue a case and get service connection granted when you don't otherwise have a link directly to service. Oftentimes we see veterans that come to us and they say, I've got this disability. I know it's somehow related to my service, but they don't have obvious exposure in service. They don't have a direct incident that happened in service, like a fall or whatever else in service. So what we'll do is we will take a look and see if that condition can somehow be linked to an already service-connected disability. And if it can, there's your secondary service connection.
Absolutely. I think it's important to note, too, like you said, that it's a way to boost your rating. But unfortunately, as our viewers know, VA math is not straightforward. It's quite complicated. So that secondary rating will be combined in with your total other ratings, but it should still give you a boost, and it's important to explore. If you're interested in taking a look at how a secondary condition can boost your combined rating, we have a disability calculator on our website, so be sure to check that out. So let's dive in and talk about some common secondary conditions that we see that people can file for if they have an already service-connected mental health condition like PTSD, anxiety, or depression, just to name a few. Okay, with that, let's go into some common secondary conditions. I'll get us started. First is obstructive sleep apnea, and I've just seen this absolutely explode in the last 5 or so years. It's a very common condition that a lot of veterans come to us seeking assistance with, and it can be related back to service-connected mental health conditions, particularly PTSD, but also anxiety and some other conditions. There's an interplay between that hyperarousal and startle response that you see in our clients and veterans out there who have PTSD and the obstructive sleep apnea process. The diagnosis of sleep apnea does require a veteran to have a sleep study showing that they have sleep apnea. And you can get actually a pretty high rating for sleep apnea. If you were prescribed a CPAP machine or some other type of air breathing pressure machine, you can get a 50% rating, which can have a significant impact on a veteran's combined disability.
Yeah, that's a big one, and one that we see make a meaningful change in a veteran's life if they can get it granted. The
Absolutely.
50% rating. You were talking about VA math a little while ago.
Yeah.
It's so difficult, unfortunately, to kind of build a veteran's case, 10% here, 20% there, at some point to reach what most veterans want, which is 100% total rating. You're going to need some big chunks along the way, right? And so this is one that if the evidence is there, if you can get it granted, a 50% for having a prescribed CPAP goes a long way to getting to that.
And just a little caveat, there are proposed regs, or there's rumors of proposed or rumors of proposed regs?
Proposed.
Proposed
Yep,
regs, that's
proposed,
right.
Yep.
That would change the rating criteria for sleep apnea, but it's sort of been lingering in the background for years. There's been no action, so...
It would significantly, in my opinion, looking at the proposed regs, it would significantly change how a veteran would have to go about not getting service connection for the condition. It doesn't change that, but how sleep apnea would be rated once service connection is granted. And frankly, it would probably make it more difficult to receive a higher rating.
Exactly.
So it's not law today. It's proposed. It's a regulation that's proposed. I have not heard anything on that as of late. And so, we certainly keep an eye on those things here, as I know you know, and we will provide updates if we hear anything, but no change as of right now.
Right. And so the takeaway from this really is that if you have sleep apnea, a diagnosis of sleep apnea, you're using a CPAP machine, and you're wondering, hey, is this related to my service-connected PTSD, my anxiety, my depression? Make sure you go talk to your doctor and see if they have any recommendations for you, and go ahead and file because we don't know when that reg might change.
And if you get the claim in before the regulation changes, then guess what? Even if the regulation is harmful to your case, you still benefit by whatever is most favorable. And in this case, it looks like that would be the old regulation.
Absolutely.
So if you think you have it, file it.
All right. What else can veterans go ahead and service connect? Some common conditions that are secondary to service-connected mental health disorders.
Yeah, hypertension is another big one, right? And so you have, I'm sure, heard the phrase, stress does a number on your body.
Mm-hmm.
It's true.
Yep.
It is true. And prolonged elevated levels of stress can often lead to increased levels of blood pressure. Which is hypertension, essentially. And so in the mental health context, which I know we're talking about here, mental health disabilities such as anxiety, PTSD, just to name a few, often can cause or worsen a person's blood pressure readings. And so, again, going back to the tenets of secondary service connection we were talking about, if a service-connected mental health condition such as PTSD or anxiety causes or worsens a person's high blood pressure, then they can potentially get service-connected for hypertension.
Right.
A couple things to note are that, it really, in terms of rating blood pressure, it's pretty mechanical. It comes down to what are the veteran's blood pressure readings. And so the best evidence is really treatment notes that show on a kind of a continued basis, prolonged basis, what the veteran's blood pressure readings are. we've had some veterans that keep blood pressure diaries,
Mhm.
and that's a great piece of evidence. If you can show the last 6 months and what those are, you could submit those to VA as evidence. But overall, like I said, it's really one of those conditions that really I see very frequently resulting from a veteran's PTSD or anxiety. You still need a diagnosis, and you still need medical evidence establishing that hypertension is related to the underlying service-connected mental health condition.
Mhm.
But if you can prove that, then you should have a solid claim for secondary service connection of hypertension.
Right. And I'm going to jump around and ahead a little bit in our list of things to talk
Sure.
about, because there's another one that I think is really important that's linked to hypertension, and that's cardiovascular disease
Yes.
and stroke. And
Yep.
so while hypertension is going to result in maybe a 0% rating or a 10% rating if you have persistent readings, I think of 100. Is it diastolic or systolic? I forget. I always invert those. So
Yeah.
look up the DC, or continued use of medication to maintain a healthy level of readings. But getting hypertension service connected could actually help you later down the line if you have other things that are then secondary to that hypertension. And so it's all a continuous chain.
Yes.
And that's where
Yes.
it's really important to consider service connection for hypertension if you also have something like cardiovascular disease or CAD. Or even, a stroke, because those elevated levels of blood pressure can certainly lead to various heart disease and ultimately, unfortunately, a stroke, which can have really catastrophic impacts for veterans, on their day-to-day functioning, and open up really sort of higher levels of compensation that you're entitled to if, you lose your ability to speak, you're paralyzed on, certain sides of your body. So that link in the chain, that hypertension link is super important. And again, maybe it's not going to boost your combined rating the way that 50% for sleep apnea might, but it might be a really important link in the chain if you unfortunately develop more serious complications down the line.
Yes, absolutely.
All right. So another one that's very common that we see a lot, and keeping with that anxiety and sort of tension tact, are migraines. So migraines can be linked to stress. They certainly are made worse if you have insomnia and PTSD. And so just the actual underlying mental health condition can cause or worsen headaches. Another way that you might not think about a mental health condition triggering migraines is medication. A lot of over-the-counter and prescription medications can actually trigger migraines or make them worse. And so that's something to consider when you're thinking about the interplay between your various conditions and how they might be related to service. Certainly something to read, the warnings on your prescription labels. Don't stop taking your medication. I'm not advocating for that at all. But certainly talk to your doctor and say, hey, I have both of these things. Is there any relationship between the two? And if there is, you should file for it. Absolutely.
That's, and that is a theme that runs through a lot of these. The use of medication leads to some of these secondary conditions.
Right.
And the next one up that we're going to talk about is erectile dysfunction, or I'll just call it ED for short. But ED is one of those conditions that is often caused or worsened by anxiety, again, PTSD, or as we were just talking about, the medication used or prescribed to treat those underlying conditions.
Right.
And so you had mentioned, a minute ago, kind of building the evidentiary chain that ultimately gets you over the finish line to where you need to go. And this is a great example of that. Many medications, as a side effect, a known side effect for treating ED, will cause that condition. A known side effect for treating PTSD or anxiety will lead to a diagnosis of ED. Now, what's interesting about ED is that the rating for ED, the standard rating for ED, is actually
0.
It's a 0, right? So I get veterans all the time that ask, well, if it's a 0, sure, it's nice to have the recognition that VA, my time in service, led to this condition and that VA is recognizing that. But at the end of the day, we're talking about compensation here.
Right.
That's what I'm very much concerned about. And a 0% rating doesn't do anything for me. But it does do something for them. And what I try to explain to clients is that, sure, the 0% rating in and of itself doesn't do anything. But the diagnosis of ED and subsequent service connection for ED can open a separate benefit that will lead to compensation. And that benefit's known as special monthly compensation, subsection K, but it's basically the loss of use of a reproductive organ.
Mm-hmm.
And by virtue of getting ED service-connected, a veteran can get SMCK granted.
Right.
And that leads to typically, I think it's about $136 a month additional on top of whatever overall compensation rate they're currently getting.
And what's good about that one, too, is it's not like combined into your combined rating of VA math. It is just straight on top.
It's right on top. Yep, exactly.
So certainly one to consider.
You still need it. Another common theme, you still need a diagnosis for ED. You still need to show the nexus between ED and the mental health condition. But assuming you're able to do that with medical evidence, secondary service connection is absolutely warranted and will lead to additional benefits.
Right. All right. Another one that we see all the time are sort of gastrointestinal disabilities. And I'm sure you can imagine that heightened levels of stress and anxiety, when I'm just stressed, just basic level, you get butterflies.
Yep.
So now you have a really severe case of PTSD or anxiety. It can certainly lead to or aggravate certain GI symptoms, particularly GERD, reflux disease, or IBS. And so we see a lot of clients come to us, with those two conditions. Also, both conditions can be aggravated by the medication you take for various mental health conditions. So really echoing the themes we've been talking about, you still need a diagnosis, you still need a medical nexus between the two, but something to consider if you have either of those conditions.
The next condition, I'll call it TMJ. It has a long medical technical name that I'm not going to even attempt to pronounce to save myself the embarrassment.
You don't want to say bruxism?
You know what?
It's just bruxism.
Essentially what we're talking about here, right, is clenching of the jaw, grinding of the teeth.
Right.
And it's not a one-time occurrence. It's repetitive disorder where, veterans due to anxiety or PTSD really can't help but constantly clench their teeth, grind their teeth, clench their jaw. And it leads to, serious issues and limitation of motion for the veteran's jaw. This, again, is capable of being service-connected secondarily to the veteran's underlying service-connected PTSD or anxiety. And if it is, then separate ratings are available for TMJ, bruxism, and that can just help build the overall disability picture for the veteran to kind of reach the goal of 100% or whatever the goal is for the veteran.
Right. All right. One that I think that people don't necessarily know about or are flat out told by VA, no, this can't be service connected. And I think the truth is somewhere in the middle there is substance abuse. So you can't actually get a service connected disability rating for alcohol abuse, opiate abuse, cigarette nicotine dependence. You can't get service connected for that by law. You're not allowed. However, if you are using alcohol to self-medicate, you're smoking a ton of cigarettes to calm your raging anxiety. If you, let's say had an orthopedic condition, you're prescribed some opiates for that treatment of that pain, but you also have a mental health condition and the interplay there doesn't go so well and you end up becoming addicted to those opiates. If they later cause something else, for example, fatty liver disease, if you end up with pancreatitis or hepatitis due to the use of substances, and that substance use is because of your mental health condition, that resulting disability can be service-connected. So substance abuse can be the intermediate step between your mental health disability and service connection for something else. And so we do see this, unfortunately, a lot with veterans with mental health conditions. They've been maybe not getting the treatment they need, haven't had access to the treatment they need. And so to quell the symptoms, they self-medicate either with drugs or alcohol just to feel a little better. And then over time, it can lead to some really severe consequences. So just know that is a possibility. And again, you can't get service-connected for alcohol use itself, but particularly if you have a condition where VA's rated it in the mental health disorder, for example, PTSD with alcohol use disorder right there in the rating, you should be able to get these resulting conditions service-connected again with a diagnosis and a nexus opinion.
Yeah, and it gets confusing for veterans sometimes. I'm sure you see this all the time. They'll receive the rating decision. As part of that rating decision, there's something attached to it, usually at the end, called a code sheet. And it lists all the veterans' claimed conditions, There are claimed conditions that have been service-connected. There are claimed conditions that have not been service-connected. It gives a review of what their overall rating is. To know oftentimes whether the veteran's substance abuse or alcoholism has been included as part of their underlying service-connected mental health condition, you can look in the code sheet.
Right.
And on the code sheet, it will often say, for example, service-connected PTSD, depression, anxiety, to include, substance abuse, alcoholism. And that doesn't mean that is, as you said, individually service-connected on its own, but it's being lumped into as a part of the underlying mental health condition, the service-connected PTSD or anxiety.
Right.
So that is helpful if you're looking to pursue a secondary claim based on the substance abuse. You can point to the code sheet and say, well, VA recognizes that my substance abuse is part of my underlying service-connected condition, and therefore it can be used as the intermediate step, as you suggested, that can lead to that next secondary service connection condition down the road.
And you're likely, you can chime in here if you think I'm wrong, but you're likely going to need to have your own doctor, your own treating psychologist or psychiatrist or therapist comment on this. I will say that the VA compensation and pension exams we see on these issues are not great. And, substance abuse disorders can be their own individual diagnoses. Just because you have both does not necessarily mean they're connected. And I think that the compensation and pension examiners have a real hard time seeing the link. They just see the diagnoses and say, no, this is why you have this is its own diagnosis. It's nothing to do with it. So you're going to need most likely to have your own doctor write a letter on your behalf about the nexus or talk about, how your use of that substance or alcohol was because of your mental health condition. So something to keep in mind when applying, and don't lose heart, but just be prepared that C&P exam is likely to not be what's going to get you across the finish line. Yeah,
absolutely. I couldn't agree more. We see it all the time, and it almost always requires further action from us, our own medical opinion. It's something that VA, for whatever reason, whether it's training or whether it's something else, they don't often just on their own include that. So it's something that takes an extra step, usually, first to identify that it's an issue, then once you've identified that it's an issue in your case, to actually do something about it.
Right.
The next issue we have is diabetes, a very, very common condition, and a condition that can be caused or aggravated by various mental health conditions. Where I see it the most actually is, again, through the use of medication used or prescribed to treat the underlying mental health condition, building on the theme. And so with diabetes, it's the condition, once service-connected, is often rated by insulin use or whether the veteran has or to what extent they have a restricted diet. But once service-connected, secondarily to an underlying mental health condition, diabetes itself can be used to link other, sometimes physical or neurological conditions. Peripheral neuropathy comes to mind. A veteran who has diabetes often has other, unfortunately, secondary conditions that stem from the diabetes. So it's just, we're building the chain little by little to try to encompass all the veterans' disabling conditions and link them back to something that can be pegged to service. And in a lot of these cases, as we've been talking about, it's the underlying anxiety, PTSD, depression.
Right. And so this is, of course, not a complete exhaustive list of all the conditions that could be claimed secondary to mental health conditions. So there are a whole host of other things out there. But just remember that if you get this granted as service-connected secondary, it can be either, directly due to, or it could be aggravated by your mental health condition. That new rating is going to be combined with your current combined rating. So if you want to take another look, again, I mentioned, we first started chatting about this, about going to our VA disability calculator. You can take a look and see what getting an additional 50% might do for your overall monthly compensation rate. We also have a back pay calculator where you can see how much retroactive disability benefits you might be entitled to if you're able to secure these additional benefits.
One final closing thought. If by reasons of VA math, a veteran is unable to reach a 100% combined disability rating, even after filing and getting many secondary claims granted, but they're unable to work due to their service-connected disabilities, there's still an opportunity for the veteran to be paid at the 100% rate, even if they're not combined at the 100% rate. And that benefit is called TDIU, or total disability based on individual unemployability. And what the TDIU benefit essentially does is allow for veterans who have service-connected disabilities to prove that those service-connected disabilities, or really the functional limitations that stem from those service-connected disabilities, that's the cause for them being unable to work. And if they can show that, then, in theory, regardless of whether the combined rating is a 10% or a 90%, TDIU can be granted. I think it is, when I've seen cases before, a veteran will come to us with a combined rating of 90% combined. And if it's a flat 90%, I believe the math that we've worked out is the veteran would need a separate 50% rating at minimum to bring their overall combined rating up to a 100% rating. Getting a 50% rating, a separate 50% rating, is not that easy.
Right.
And so even if you get to 90%, you're still far away sometimes from getting to the 100% combined rating.
Right. And to be clear, that's not even 90. That's if you're at like 94.
Oh, is it?
Yeah.
That's true.
So if
That's
you're
true.
at straight 90, another 50 is not going to get you to 100,
Yeah,
which
so
is shocking.
It's hard. It's very hard. And so a lot of times the best avenue, if a veteran is actually unable to work due to their conditions, is to pursue TDIU.
Right. Well, thanks, Mike. If you are dealing with a service-connected mental health condition, getting service connection and compensation is the first step, but it's not always the last. You may be dealing with a variety of physical conditions that result from that mental health disability. And so if you need assistance with getting service connection, filing an appeal for service connection for a secondary condition, please reach out because maybe we can help. Let's talk about some legislation.
Sounds good.
All right, it's been a busy year, and we have another piece of pending legislation to talk about. The Veterans Appeals Efficiency Act of 2025, also known as HR 3835, is currently being considered by the House of Representatives. Last I checked, it had made its way to subcommittee hearings, and those hearings were held at the end of June. There's a companion bill in the Senate. I think it's S 1992 or something like that. You can look it up. That's just been referred to subcommittee hearings. So this is nowhere near finalized. It still has to go to committee. It'd have to come out of committee. There'd likely have to be reconciliation between the House and the Senate if either chamber passed that version. So this is all
a long ways away.
Long ways away.
Yeah.
However, we do want to get ahead of it, talk to our viewers about what this legislation means and what it's proposing to do. Because as we've reviewed it, there are some great things, some things we really like in the legislation. And then there are some things that we really do not care for and don't think are going to help the veterans that we serve and veterans writ large. So let's dive into some of the proposals, Mike. So first, it proposes some annual reports on claim timeliness and appeals dismissals, like that.
Yep.
Like more reporting, like insight into what's going on in VA and what our clients can expect. So more reporting, more transparency, that's great. Speaking of transparency, it also talks about making how claims get expedited at the board more transparent. What are the actual rules for expediting your appeal at the board? We know some of them, right? But what is the board actually doing to expedite? How do you end up on that expedited list?
Again, no problems there, probably.
Right. Yeah, no, completely on board with that. And it also recommends some technology upgrades for VA to track remands. How many times is a case being remanded from the court to the board? How often is a board member following that remand instructions?
It would be nice to have that information,
right?
wouldn't
Absolutely. So we are all for those types of proposals.
But, I think the second part of this is that the bill is filled with good intentions, but really significant risks.
Absolutely.
Here at CCK, we, of course, support faster, smarter decisions and overall adjudication. But it has to provide fair decisions to veterans, and it has to overall benefit veterans.
Right.
Two areas of the bill in particular that are significant risks or raise significant red flags to us here. The first being claim aggregation without the proper safeguards, which we'll talk about, of course. And the second is expanded judicial authority for the Court of Appeals of veterans' claims.
Right. All right, so let's talk about that claim aggregation without opt-out provisions.
Yep.
So the piece of legislation proposes that the Board of Veterans Appeals chairman can consolidate appeals with similar facts, questions of fact, or questions of law, and decide that shared issue in one go. It sounds efficient.
Sounds good,
It
right?
sounds great. Like we have, 5,000 appeals. They all pivot around this one question of law. What is the standard in a VA examination for aggravation? Is it permanent worsening or is it something else? Or a question of fact, were veterans at X location at X time frame exposed to chemical X? So those questions, it sounds efficient. However, it could delay complex claims with very obscure medical details. It risks maybe a weaker case affecting a stronger case if the facts aren't so great in one case but really strong in another. How's that going to shake out? And it introduces confusion at hearings and evidence submission. How is a veteran going to know that they've been opted into this? What notice requirements are required by VA to tell a veteran you've been combined in this appeal? There's just so many hurdles in the way to making this a good process for veterans that just doesn't seem great. Now, the one instance in which I could have seen this being helpful, and it's way too late for that, was pre-PACT Act.
Sure.
When we had how many veterans of the Vietnam War who served in Thailand fighting day in and day out to prove that they were exposed to herbicides just like boots on the ground in Vietnam. And they were. We know for a fact they were. There was lots of evidence there were. There was a VA internal document saying they were. VA issued a training letter saying, hey, these veterans were likely exposed to herbicide use at air bases in Thailand. And we finally had M21 provisions, VA internal adjudication manual, giving guidance to the AOJ and to others at VA about how to adjudicate these Thailand claims. But they just weren't granting it. And so if you went to the board, it was completely scattershot whether you were going to get a VLJ who, one, knew about all these provisions,
right. Yep.
and two, agreed with them. We had some VLJs that completely got it. They understood the training letter. They understood the evidence. They understood what arguments we were making, showing, Mr. Veteran was in flight control and on the flight line of this Royal Thai Air Force Base directly next to the perimeter and saw people spraying daily and now has all these conditions that are historically presumptively due to herbicide agents. Please grant service connection. Some people really got it. And then you had VLJs who just flat out refused to acknowledge that there was even evidence of herbicide use at Thailand and just even would go so far as to tell the veteran, you're incredible because you claimed this. There's no provision in VA law saying this is true. So if we'd had that back then, that would have been great. And now we have the PACT Act. I struggle to think of how are we going to use this to efficiently help veterans with their claims. And I'm really frankly struggling to think of a good example of when I would want the chairman to have this authority.
And, a piece of this is really, we want veterans to have control of their own destiny for their own case.
Yes.
Simple concept, one would think, right?
Choice and control.
Choice and control. I don't know where I've heard that from before, but
VA.
So I think any provision that would grant this authority has to come with the veteran's ability to opt out.
Mm-hmm.
Otherwise, you are forcing veterans to have their case decided alongside and potentially get swept up with other veterans' claims. Because to be clear, what we're talking about here in this proposal, which again is not law, but it would allow VA to determine if there are common issues of law or fact between different veterans' cases that are pending at the board and adjudicate them collectively. Now, yes, each veteran would be entitled to their own decision, but there are a lot of veterans that might not want their case to be collectively decided with a bunch of other veterans' cases who are pending.
Right.
And so, an example I can think of is, and, we see this quite frequently, is there's a question about the validity of a particular VA exam. And we're making an argument, not a factual argument, but there's something maybe fundamentally incorrect about the exam that could potentially affect a number of different veterans who all have cases pending before the board.
Right.
We may make arguments that say, sure, the validity of the exam is it's wrong. We would ideally like a new exam, but we don't need a new exam necessarily for you to still grant my case. And so we would, in that instance, probably want the board to not remand along with the other veterans' cases for a new exam based on a collective fallacy in how the exam was compiled. We want you to grant the veteran's case in this individual case. And so without a veteran's ability to opt out because they see how their case might individually benefit from particular legal arguments they're making, they don't have choice and control over their case. And so that's a big issue here. There's also just, the legislation, if you read it, the proposed legislation, if you read it, in my opinion, it's not clear at all about what the procedures would be on how to actually achieve this. And so the key is no veteran should be harmed by this. And until that is crystallized, it's difficult for us to, I think, say that this particular provision would be overall beneficial for veterans.
I agree. All right. The second piece that we're concerned and actively monitoring includes expanding jurisdiction for the Court of Appeals for Veterans Claims. So right now, the court can hear final decisions from the Board of Veterans Appeals. But this bill lets the CAVC review class actions, class certifications, which frankly, they can now.
Right.
Federal Circuit said they can review class actions, and there's a number that have been filed. CCK just filed one recently, along with our colleagues at NVLSP. So check out our press release on that if you're interested. But fine with that. Class actions, that ship sailed. We know the CAVC can do that. But the other thing it allows for is this sort of partial jurisdiction. So you can take a limited issue of fact or law up to the CAVC. They can review it and send a limited remand back to the agency to fix something, but retain jurisdiction. It just sort of, I think, frankly, makes it a procedural mess.
Yes.
CAVC is not set up to do this. The board is not set up to do this. And both, I think, have said they're not interested in doing this.
They have. And if you think the process is a little chaotic now, or if the court's docket is overburdened now, just wait until they have the ability or requirement, perhaps, to review non-final VA decisions, like supplemental claims. And so this, in my view here, it creates an overlapping and confusing jurisdictional procedural lay of the land for veterans, especially veterans who aren't represented, to have to navigate through.
Right.
The AMA system, the appeals modernization system, the new VA procedural system has only been in effect since 2019. And so not even 10 years yet. So this really throws a wrinkle into the procedural aspects of working a case, and it's unclear. It's really unworkable, but it's unclear to me how this would even work without, like I said, burdening the court or creating a situation that veterans could easily navigate.
Well, the other thing is you have to remember that when you're before VA, so the regional office or the board, it is supposed to be, and it might not always feel that way, but it is non-adversarial. Yep. There are no two parties on either side. The VA is not against you. They are supposed to be helping you through the process and help you with your claim. It's supposed to be veteran-friendly, yes, non-adversarial. There's no one fighting against you. When you get to the court, it is the first time, it is adversarial. It is absolutely adversarial. It's a regular legal process. There is Office of General Counsel that represents VA and their interests, and then a veteran might be pro se by themselves, or they might have an attorney representing them. And so to have this jump back and forth from an adversarial to a non-adversarial system with these limited remands will be confusing for veterans and advocates. So I think that it's just, like you said, muddied. The other thing that off the top of my head, I know the CAVC has had a record number of appeals this year. And so this would only increase that process without adding additional resources to the CAVC. So I really struggle to see how that would work.
There's a natural vetting that is supposed to happen. I'm not saying it happens all the time, but there's a natural vetting process that happens in a veteran's case, whereby they file a claim at the regional office, they may have to appeal. They have to appeal a few times. They go to the board. They're adding evidence. They're adding legal arguments. And then the way the system works now is once a case reaches the Court of Appeals, we're really looking at briefing a very, definitive legal issue. We're not looking at the case necessarily, where we're looking at every potential issue that has come up in the case. Think of it like, the tip of a pyramid, if you will.
Yeah, it's a funnel.
It's a funnel, absolutely. And so there's a certain efficiency that comes with that. And I think that benefits veterans overall, forcing the court to look at a particular legal issue and dealing with that legal issue. Whereas if now they're forced to, in addition to that, adjudicate non-final decisions, I view that as being, as you said, muddying the waters in a way that is not beneficial at all.
Agreed. So we think that some parts of the bill are promising. We talked about how we support improved tracking and data reporting and transparency into what VA is up to, what's happening with remands, what's happening with appeals. We like that. We like more information for our clients and our viewers. But we have concerns about efficiencies overriding fairness. Would not support this bill unless it has opt-out provisions for veterans to not participate in aggregate action. We want to avoid overloading the CAVC. Right now, the whole adjudication process at the CVC, it's not lightning fast, but it certainly is quicker than going through the appeal process to the board. And so I would really be, I would loathe to see the court burdened where veterans were waiting years to get a decision from the CAVC. And we just have to safeguard veterans' rights, make sure that each individual case gets its due time and each veteran gets to be heard on their individual matters. So for more detail, be sure to check out our blog post that we have about this particular issue. And as updates come in, we'll be sure to let you know. Our topic in this segment is things that only a VA-accredited attorney or representative can do for you. So why hire a VA lawyer or rep? I think that's a question that a lot of people have. Are you just hiring someone to file paperwork on your behalf? Can I do this myself? Aren't there a million services online that will help me fill out this paperwork? And the answer is yes, we can do some more things for you than just filling out your paperwork. And we absolutely can do a lot more than just filling out your paperwork. We actually have some unique tools and value adds to bring to veterans out there who want assistance with their VA disability claim from an accredited rep. And so in this segment, we're going to talk about a few of those tools. We have the CAR program, VA System Access, which is absolutely critical to our practice. We have our years of experience. CCK Law has been in existence now for 20 years, over 20 years. And so lots of experience here. And with that comes skills, courtroom skills that we've learned over the years, and also the relationships that we have built both within the VA legal community and with VA itself, with the people that work there. So we're going to talk about all of these tools and advantages that accredited agents and attorneys have.
So to get us started, there's something known as a claim accuracy request, or you might hear it called CAR. And this allows a VA-accredited attorney or representative to request a expedited review or appeal of a denied claim.
Right.
We use these a lot, and I can say from personal experience that they come with great success. There are specific rules that you have to follow in order to file a CAR review. But say a veteran receives a decision, an unfavorable decision, and their options are to go to the board, and it could take a long time before you receive a decision at the board, gather additional evidence, file a supplemental claim. Maybe a veteran doesn't need to submit any additional evidence. They've submitted the evidence, they've submitted the argument that they think they need to win the case. But they just need someone to review the case again and make a different decision, frankly. So what a CAR allows you to do is within 30 days of receiving a decision, it allows an accredited attorney or representative only to take that decision and file an appeal. And it's essentially an appeal on a higher level review form. It's the same form. You have to clearly mark that it's a claims accuracy request review, CAR.
There's 2 R's there.
But within 30 days, VA has said that they will attempt to deliver a decision, and we have seen that be mostly true. This often comes in handy when you can identify what VA calls an obvious, whatever that means, error in law or fact. And so we typically use this to identify procedural errors, usually in the context of identifying an earlier effective date for a claim. VA does this thing often where you file a supplemental claim, they grant the condition, but it's only back to the date that you file a supplemental claim, even if you filed an intent to file almost a year prior.
Right.
Or maybe the supplemental claim is actually a supplemental claim appeal.
Continuous pursuit.
It's a continuous pursuit of an underlying issue that has maybe dated back 5 years, VA takes the supplemental claim appeal and grants back to the date you submitted the supplemental claim appeal because they're mistaking the appeal with what they think it is, which is a claim, which is incorrect.
Right.
And so a CAR is our ability to take that decision and quickly turn it around, identifying the obvious error in law, and then get a decision for our clients pretty quickly. And we've been quite successful with that.
And it's good for obvious factual errors, too. You mentioned some legal procedural problems, but for example, things like, there's no evidence the veteran served in Southwest Asia. Therefore, PACT Act presumptions don't apply. The DD-214 clearly shows, not only were you in Iraq, but you got, a Purple Heart for an injury you had there. So really obvious factual errors. This allows veterans to fast track an appeal, get the right decision without having to go through what can be a lengthy process to appeal it, either with a supplemental claim or, heaven forbid, take it to the board and waiting in line for years.
Yeah, that's a great point. I can't tell you how many times I'm on the phone with a veteran, and what they say to me is that this is in the record.
Right.
This is clearly marked in the record, and VA just overlooked it. And as someone who has been doing this for a while, I can believe that VA overlooked it. Newer practitioners might say, it seems unlikely that VA would overlook something so obvious. But they do. And to your point, it's nice to have the ability as an accredited attorney to be able to tell the client, well, there's a remedy here, right? You don't have to sit for months and years and wait for VA to correct this obvious error.
Right.
We've got something that we can do here to fix it for you.
That's great. All right. Another tool that an accredited attorney has in their toolbox is access to VA systems.
It's a big one. Yeah.
And this is something that we've had as attorneys and agents have had to fight for a long period of time. And not every accredited attorney or agent uses this. So you make sure to ask when you're considering hiring someone, do you have VBMS access?
Not VA.gov, right?
No, not VA.gov. You want someone who has access to the Veterans Benefit Management System,
Yes.
which is where VA keeps the electronic record for every veteran's claims file. So that file that VA has is your case file. Any other type of legal work, litigation, let's say, car accident, PI, your attorney's going to have a case file for you. It's going to have all your medical records. Going to have police reports. It's going to have any pleadings that were submitted to the court on your behalf, discovery that gets taken. And so think of this like your claims file. It's electronically stored and maintained by VA. So all your service personnel records, your service medical records, the claims you filed, anything you've written to VA, phone calls you've made that have been notated, all of those are stored in VBMS. And so the ability to see in real time what VA has, how they've recorded it, what they're marking it as.
That's an important piece, the notes.
Yeah, who's looked at it.
You can see sometimes the steps that VA has taken on your claim and where your case is being sent and who's working on it.
Exactly. Yeah. So it really is a vital piece of information. And frankly, I don't think that you can really operate this in the level you need to with today's complexities, especially in the AMA, without VBMS access. So accredited attorneys have access to this. They have to go through a process to get access. You have to get a PIV card from VA to go get fingerprinted. You have to maintain certain CLE requirements and certain trainings. You have to maintain access to it. And there's a lot of rules and safeguards in place, as there should be, because this is super sensitive information. But, it's really vital to have access to this. And so critical that VA accredited attorneys can get it. There's a couple other internal programs that VA uses that accredited attorneys can get access to. One is Share, and that's huge. And that's the payment history that VA gives. So we can check and see, is the veteran getting their checks? Is it the right amount? When has that payment been issued? And that really alleviates a lot of confusion and frankly, concern on our clients' parts.
Yeah, veterans call up and they say, hey, I haven't received my check. If you don't have VBMS access or access to Share, actually, you wouldn't be able to look for them and see, oh yeah, it's been issued. It's maybe a paper check, you can tell. It might take a couple days. Or no, VA has not. Let us reach out for you.
Right.
You're really flying blind if you don't have access to Share, because it's difficult to know what VA is doing with a veteran's payment.
Right. And one other program that we can access, but very limited, we don't have good insight or view into this, is CaseFlow, which is the board's case management system. I wish we had a better insight into what goes on in there, but at least it allows us to see high level what's happening with an appeal at the board.
Experience matters. And like all things in life, the more you do something, the more experience you have with it. At CCK, we have over 500 years of collective experience, which is, I know.
That's bananas.
I almost didn't believe it myself. I had to look it up.
I didn't believe it. You wanted to fact check that one?
But it just goes to show, working thousands of cases builds that muscle. You know what to do instinctively in a veteran's case. You know which theories work, which theories don't work, which theories of secondary service connection work, which don't. You know which medical opinions you might need to get, which ones you can't get. And so the experience of having an accredited representative really does make a difference in a veteran's case.
Yeah. And you talked about experience. That experience also applies to courtroom experience. So at CCK, we have a very large practice before the CAVC, Court of Appeals for Veterans Claims. And the CAVC was founded in the 1980s to provide veterans a legal route to challenge decisions by VA. Before that, it was the board reviewing what VA had done, except the board is part of VA. So it was VA saying, yes, we did it right. So you can only imagine what that era was like. But now we have the CAVC, which is a federal appellate court outside of the VA system. And it is very different, though, than practicing before VA, because it's adversarial versus non-adversarial. So there is an attorney on the other side representing VA and their interests. And you have to be versed in appellate practice. Appellate practice is different from regular trial work and litigation. For those attorneys out there that are watching, that are thinking about, dipping their toes into VA world, and maybe I'll start with a CAVC case, it is not just your standard lawsuit. It is an appeal. So you're looking at questions of law. You have to understand the appellate procedure and the steps that need to be taken to get a favorable result for your client. And so, working with a firm that has accredited VA attorneys that also have CAVC experience can be really helpful to veterans, particularly when they have a complex legal issue that we know is not going to get resolved by the board. It's going to have to go to court to get sorted out.
Yeah. Finally, the last thing is sometimes who you know is better than what you know. Not always, but sometimes.
Yep.
And the fact is that as big as VA is, the veterans legal community is rather small.
Right.
And so having established relationships with both other practitioners and people within VA can make a difference in a veteran's case. Now, I'm not suggesting we can call up the local regional office and say, hey, let's bump this guy's case.
We in fact
That's
cannot.
Unethical.
Well,
we do not do that. We cannot do that.
And we can't do that. Even if we wanted to, they can't do it.
Exactly.
It's in a national work queue.
That's not what we're talking about. But what we're talking about here is knowing the right lever to pull in a certain situation. And so, for an example, it happens all too often, unfortunately. A veteran files a claim or an appeal, and they haven't heard anything from VA for months and months. And they're wondering, does VA even have my claim? And sometimes the answer is they have it, but they don't know they have it.
Right.
They haven't established, in their work queue, the correct task, if you'll call it that. It's called an end product, but that's a technical term, to work the particular claim or appeal. And so using VA systems, which you talked about a little bit earlier, we would be able to take a look and see that that is in fact the case, and then know the correct person to reach out at the regional office to say, hey, look, we submitted this, the veteran submitted this on this certain date. We can see that it's not pending. That's why there's no action been taken on it in months. Can we get it established? We're not saying how to grant it or whatever, or even when to grant it, but we need you to put it on your radar and flag it so that the case gets worked.
Right.
Things like that, knowing the correct hearing coordinator to reach out to. There are various hearing coordinators all throughout the country. And there's a list of those hearing coordinators. You have to contact the correct hearing coordinator if you want to make sure that a hearing is properly scheduled or withdrawn in a timely way. So kind of knowing, like I said before, which buttons to push, which levers to pull, in the appropriate situation, who to speak to, who not to speak to, who to avoid. It does make a difference in a veteran's case.
Absolutely. And while we can't, push things through necessarily faster than any other veteran's claim, what an accredited attorney with experience and connections can do is avoid unnecessary delay that might happen if someone wasn't keeping an eye on this. Also comes super important when it comes time to a veteran getting paid, right? Making sure that VA has issued that retroactive payment. What is the holdup? We know who to contact to find out. Why is this going, under another level of review? Are there offsets happening? Contacting those fee coordinators can be really helpful to veterans, especially at the end when they're like, all right, VA's granted me this benefit. Where's my compensation?
Yep, exactly.
Welcome to the CCK Law Q&A segment. These questions have been inspired by our viewers. We've heard from clients, we've heard from commenters and other practitioners. And so remember that all of these answers are just informational. This is not legal advice, but we wanted to take a time to answer some questions that those of you have had. And if you have a question that you want answered, make sure you drop it below in the comments and we'll see if we can get to it in our next segment. So Mike, why don't you start us off with some questions we've gotten from viewers?
So I'm going to read this question here. It says, what about people who go from TDIU to a 100% P&T permanent and total scheduler rating? If your VA benefits letter lists you as both 100% permanent and total and TDIU, meaning unemployable, are you still not allowed to work, even though you're now 100% permanent and total scheduler? So I'll say, at first, I think it's important to recognize that they are two separate things.
Correct.
TDIU is a benefit awarded when a veteran's service-connected disabilities in totality prevent the veteran from being able to obtain and maintain what VA calls substantially gainful employment.
Right.
A veteran does not have to have any particular combined disability rating to get that benefit, right? I mean, it's helpful the higher the combined rating is, and there's specific regulations that state, if a veteran is combined at 70% in total, there are certain avenues that make it easier to get that benefit, generally speaking. But it's a separate benefit from when a veteran has a number of different or perhaps one, but a service-connected or service-connected conditions that collectively, using VA's mathematical formula, add up to a 100% scheduler rating. So they're separate things. So to answer this specific question, I would say, and they say, are you still not allowed to work even though you're now 100% permanent and total scheduler? As a general rule, I would say, correct me if you think I'm off here, but as a general rule, a veteran with TDIU typically can't work and receive the benefit. There are exceptions for certain. We may talk about more of those later, but generally, a veteran who is receiving TDIU has been given that benefit because it's been deemed that they're unemployable. So if a veteran returns to work or is working, there's a significant likelihood that that benefit could be reduced or taken away. The other hand is a veteran who has a 100% combined disability rating. They may have that through a number of 10% and 20% and 30% individual ratings.
Right.
Sometimes you see a code sheet which lists all the veterans' conditions that have been service-connected, and it could run a couple pages long in some instances. In that situation, the 100% combined rating is awarded to recognize all of those individual disabilities and not necessarily awarded to say that the veteran is unemployable. So a veteran who has a 100% combined disability rating, permanent and total, could in theory still work and still receive the 100% permanent and total disability rating.
Right. And so I just caution whoever asked this question, make sure you actually have the Scheduler 100, that you see in documents from VA, your combined rating is 100%, because you get paid the same amount at 100% and TDIU. And that's why I think veterans get confused. They're getting, was it $39.97 a month with no dependents? And so they think that they have 100%, but in fact, they're getting TDIU. So find out what your combined rating is. If it's 100, you should be free to work. If you're getting TDIU, and you're not 100%, I would caution you against working. Also, beware that permanent and total rating. I think a lot of our clients, a lot of veterans who contact us seeing if we can help them get that stamped onto their rating decision. And the issue is that it's not actually permanent, right? It's permanent in the sense that VA is not going to bother you. They're going to leave you alone. But if you start filing more things, they have the right to start poking around and potentially reduce you. So permanent in total, I know, has a lot of benefits outside of the VA space. There might be state-specific benefits that veterans are looking for with that P&T status. But for this question, just take a close look at what you're actually rated for.
Yeah, it's a great point. And one final thought for this question. How a veteran has achieved the 100% P&T rating matters too. So I've seen cases where a veteran is rated 100% P&T for one service-connected condition, and that service-connected condition is, say, PTSD. Now, the way that the mental health ratings work is that a 100% rating for something like PTSD is typically only awarded when VA finds that the veteran is totally occupationally impaired.
Right.
So you can see the kind of the natural contrast there with a veteran who is, got a grant of PTSD for 100% on the basis that they're totally occupationally impaired and trying to work. The fact that they're trying to work or working can conflict in some ways with the fact that they've been granted with 100% permanent and total for PTSD. So the type of condition the veteran is awarded the 100% rating for does matter. So every situation's different and unique, but I think generally speaking, that's the difference between the two.
All right, let's take a look at another TDIU question. I have heard that in order for benefits to be reduced, a TDIU veteran would have to be found to have worked 12 consecutive months and earned wages above the poverty threshold. Does that mean if, for example, the veteran has earned more than the poverty threshold but hasn't worked 12 consecutive months, in that situation, VA wouldn't have grounds to terminate TDIU for that veteran? Again, a very specific fact-specific question, but let's talk as general as we can. So the poverty threshold speaks to a component of TDIU, which is substantially gainful employment. So TDIU is awarded for veterans who can't secure and follow, obtain, and maintain something called substantially gainful employment. If you are earning below the poverty threshold for one individual person, despite the size of your family, even if you have a spouse and 3 children, it is the poverty threshold for one, then VA does not consider that to be substantially gainful employment. Those earnings, I think it's around $12,000, I want to say. Maybe it's a little bit higher, 13?
Slightly higher now, yeah. It's 13,
it goes up
14.
With the cost of living index with Social Security, but let's say it's about $13,000. If you're earning under that, it is unlikely, not by choice, but by virtue of the limitations of your service-connected disabilities.
Exactly, yep.
VA will likely not find that to be substantially gainful. If you earn more than that, and no matter how long it took you to earn that, that's substantially gainful employment. It doesn't matter if it's a month or 12 months or 6 months. It's substantially gainful earnings. So in that respect, you might no longer qualify for TDIU. The 12-month component, I think, comes into play because VA will look yearly, and they'll get a report from Social Security to see if you have any disability tax earnings, your Social Security wages for that year. And so if they report back that you made $30,000 that year, VA may very well kick you off TDIU. It is fact specific though, and I think it gets tricky for our potential clients and clients who have maybe gig work, driving for Uber.
It's a big one nowadays.
Yeah, driving for DoorDash.
All the time. Yep.
Substitute teaching.
Substitute teaching is another big one.
Yeah, it can be tricky because the question VA has, not us, the question VA has is, okay, could you earn more if you worked more? Like, are you doing this gig job because your disabilities prevent you from showing up to a job, or are you doing it by choice because you want the flexibility of working when you want to work? We really see that with substitute teaching. It can be a really big impediment for people who are trying to get TDIU, but also substitute teach, because the nature of substitute teaching is limited. Bus monitor, crosswalk monitor, those types of things. So to this person who asked the question, VA will look. in my experience, they aren't going to care that you earned it in 3 months versus the whole year. If it's more than that poverty threshold, you've earned substantially gainful employment.
No, those are great points. That the reason why the veteran cannot work really matters here. And so to your point about the substitute teacher, that was an example I was thinking of as well.
Yeah.
We do see it frequently. The nature of the work is that the person typically works for less than 12 consecutive months in a year. So in order to prove one of those cases, you can use lay testimony,
an
affidavit. You can get tax documents. But at the end of the day, you really need to show that the limitations that come from your service-connected disabilities, and we're only looking at service-connected disabilities here, that those limitations prevent you from working more. VA will often make the mistake of saying, well, you've got this really bad back injury, right? That's not service-connected. That's the reason why you can't work. And that's an error we see all the time. It doesn't matter, as severe as the non-service-connected back injury may very well be, VA's analysis needs to be laser focused on the service-connected disabilities and only those service-connected disabilities.
Yeah.
And when looking at only those disabilities, they need to make the determination whether the veteran can work substantially gainful employment. So if you see them, and this happens often, like I said, and I know you see it all the time too, VA starts to wander and they start to pinpoint a bunch of non-service connected conditions and say that's the reason, you need to call them out on that.
Yeah. Great.
How hard is it to prove a nexus, which again is just the link between, an event in service, for example, and a diagnosis to prove service connection? Person said a VA doctor's allegiance seems like it would be really to VA, as is the CMP examiners. But low-income vets cannot afford an outside opinion from an independent doctor, and an outside doctor might not even understand what you want them to do.
This is such a good question.
It is.
My blood's already boiling for this question.
Well, I think at the outset, it's important to recognize that now CMP examiners are largely third-party contractors, right? So they're not technically VA employees. So take that.
And it shows.
And it, well, anyone who's received a CMP examination will see that that the quality is not as we might hope. But with that, I think, like we said, it's important to recognize that these are not VA employees.
Right.
So sure, perhaps the argument could still be made that their allegiance isn't with the veteran, but I also don't know that it's necessarily true that they are looking out for VA's best interests just inherently. I think my opinion is that a lot of the quality issues we see with the CMP exams have to do with just, the veteran going in and receiving a bad exam, or the examiner hasn't reviewed the record, or maybe there are, and I'm sure there are, some personal biases with the individual examiner. But I don't know that you can say that the CMP examiners writ large have an allegiance to VA over the veteran. Maybe you disagree, but I think it's more individual, and I think a lot of times it gets caught up in the bureaucracy that is the disconnect between a third-party contractor and the VA, and veterans going in and sometimes having difficulty because of their disabilities accurately reflecting what their disabilities truly are in terms of severity.
Yeah.
So there's a lot of that too.
And I think that what definitely comes through lately is, however, that independent contractor has structured their payment system with those examiners. So the allegiance might not be to VA, but the allegiance is to, how am I going to get compensated for this exam by the person I'm working for? So we've had a lot of complaints, and we've seen a number of exams that are clearly rushed, barely filled out, basically useless. Why even have the exam at that point? So, great question. Let's hit some other points of it, though, because I think it's got, 3 or 4 components here.
The second part of it, which is a great point, many of our veteran clients, unfortunately, come to us with little financial means.
Yeah.
They're in difficult positions, obviously, due to their disabilities and just life circumstances. So what does a low-income vet do who they know they need an outside medical opinion, but they can't afford one? Or even if they can afford one, they're skeptical that an outside provider would be able to fully comprehend the complexity that is VA law.
Yeah.
So with that, I think a couple things. Right off the bat, not in every situation, but oftentimes veterans can obtain a nexus letter from a treating physician. Not maybe going to be the most thorough opinion as if you were to contact an outside independent provider and pay a lot of money for it, but it can be sufficient. And oftentimes a treating physician will, provide that service and provide a letter that helps to connect a disability that they're treating for with their time in service. Outside of that, though, VA representatives or VA-accredited representatives and attorneys like ourselves, this is something we do every single day. And we know the right people to contact. Oftentimes, there is no cost to the veteran unless we're successful on that particular issue for which we obtain the opinion. And so, like I said, there's no upfront cost to the veteran at that time. And people like ourselves, we're able to help explain to an outside provider what issues need to be hit, what we need to focus on, what we shouldn't focus on, and then allow the independent nexus provider to deliver an opinion on their own that is either up or down.
Yeah.
And then we can see what the merit of the case is at that point.
And so a couple other, things that this question raised for me. It used to be when I first started doing this that your VA treating provider, your actual treating doctor, some would write nexus letters for their patients. I don't know if it's like a VHA policy or a directive, but I have heard that they have been instructed they're not allowed to do that because somehow it muddies the relationship between treating doctor and patient. So unlikely that your VA treating doctor will give you a nexus opinion.
Yeah, yep.
However, if you treat anywhere else outside VA, whether that be a PCP or any type of specialist, you can ask them. We have a lot of content on nexus letters. I hate to say, go do more research, but we have, whole videos and blog posts on what's needed in a nexus letter, the standard, as likely as not. You need to make sure that provider has reviewed your entire medical record and maybe service record too, and that they're using the right standard, that magic language that VA wants to hear. Other than that, it's supposed to be non-adversarial. VA is supposed to be on your side. The VA examiner should not be trying to disprove, but look at this in a positive light and see how they can help you. And so if you experience any situations in which you're feeling like that's not happening or aggressively not happening, speak up, let VA know, complain, appeal. Don't just let it, continue because it should not be that way.
And that brings us back to the first point, which is because we see inaccuracies and issues with VA examiner opinions so frequently, it's critical that veterans, either on their own or with the help of an attorney or an accredited agent or, DAV or another organization, you got to be able to point those things out in an appeal. It's critical that you don't just let it go, that you highlight it, you address it. We have the ability to, use case law and our years of experience to be able to identify those flaws and issues in the exam and then make legal arguments that address it.
Yeah. Okay, last question for today. Can a veteran get disability for smoking-related conditions? What if smoking was used as a training incentive when a service member was in training? Okay, great question. And this is a callback. We did a segment on secondary conditions to mental health conditions. You cannot get service-connected for nicotine-dependent cigarette use in and of itself. However, if you started smoking in service because they were in your rations, and that happened, not anymore, but they did, and you continued to smoke because of something else, we talked about that. Maybe it's a mental health condition, maybe it's a pain condition, orthopedic condition, the smoking helps you relax, whatever the case may be. You can get service connected for any conditions that result from that nicotine and smoking dependence. For example, a cancer, diabetes, hypertension,
respiratory issues,
the
obviously,
whole litany list, laundry list of things that come from cigarette use and smoking. So I hear you. I hear that, you were handed the cigarettes along with your rations. And I appreciate the sentiment that, I was given this, I should get service connected for it. But unfortunately, that's not the law. It doesn't allow for that. But it can be a link between a service-connected condition and a subsequent condition.
Yep. And aggravation here is key too. It's, the worsening of a smoking addiction due to PTSD or anxiety that ultimately, a medical provider would have to provide this opinion, but that ultimately led to one of those secondary conditions that you talked about.
Yeah.
That can provide the link as well, even if, you entered service perhaps smoking, 1 or 2 cigarettes a day, but you came out, 2 packs a day, just as an example.
Yeah, that's a great one. We've covered a lot today, from the Veterans Appeals Efficiency Act to getting conditions secondarily service-connected to a mental health condition to what can a VA-accredited attorney actually do for you. The big takeaway is that this is complicated. And just know that you do not have to go this alone. A VA-accredited attorney can help you with filing claims, appeals, gathering evidence, and assist you through the entire complicated process. If you liked this video and any of the segments today, please be sure to subscribe to our YouTube channel or listen to us on wherever you get your podcasts, Spotify, Apple Podcasts, and other platforms. And as always, be sure to take care of yourselves, take care of each other, and keep the fight alive.